Ah, welcome. Welcome to another segment of the Seek Elevation. Man, today's topic, timely, necessary. One of the things I keep hearing a lot, even from individuals in tech, not just regular individuals, I keep hearing AI is new. AI is new. I've attended AI seminars and other things to learn more about AI. And even those who are very adept in AI, people keep saying AI is new. AI is not new. The iterations of it keep changing. The iterations of artificial intelligence keeps changing, keeps getting better, arguably, for some. But AI is not new. AI means artificial intelligence. So AI is not new, neither is theft or likeness. That's what we're going to talk about today. Let's talk about AI. We need to dismantle the fear of artificial intelligence because it's been here. So, what we're fearing is the continual iterations of it. And I'm not going to say we need to dismantle some people not liking it or liking it. That's people's preference. You can like or dislike the new iterations, the large language model, and all the other ways that it is expanding. That's your choice. But let us not fear. Fear is not something that we need to possess, that we need to claim. We have to continue to show up in our power over anything. You are the human. And the only way that we can continue to show up in our power in anything is to be informed. Most of the time when we fear, it's because of the unknown. We fear the unknown. Things that we do not know elevates our level of fear. So let's get into it. This is a very important topic, especially for the ownership mindset. We need to seek to elevate. We have to elevate as artificial intelligence continues to elevate. We as humans need to continue to elevate. We can't just rely on those individuals who are elevating AI. We need to continue to learn, stay on top of it, and see how we can maintain control within our space. And as humans, we have very short memory. And so a lot of times things feel new and we think, oh my gosh, the world is over. The world is over. I have heard the world is ending or the world is over since I can remember as a child growing up. It's always, these are the times are showing its signs. The world is over. We've been hearing that. If it is ever a time where the world is over, it will be a time where no one will know that day nor time. So let us go ahead and talk about an aspect of AI that I think is very important for us to understand and to bring to memorization for some, and just to bring to knowledge for others when we're talking about artificial intelligence. So, this segment today, this issue is not about innovation. It's not about what's new or not new necessarily. It's about what is. It is about control over identity, which is an asset for us. We've been talking about that throughout. That's the theme throughout the podcast segment of season 4. Um, we know that your voice can be generated without your participation using artificial intelligence. Your image, what you look like, can be synthesized even without a camera, right? We're seeing that. My gosh, am I seeing that on social media? There are people that are posting their AI generated photo shoots. And I know we can have fun with it, to each their own, but a lot of people are literally posting it as if that is them. Just be very careful of who you show up and create to be, being two different things, especially uh, in the world of business. We know that your likeness can be monetized without even your awareness. So your likeness is not just your image, whatever it is that is done that makes somebody think about you with that particular thing. It's your particular likeness, and we'll get more into that. But the legal system when we're talking about image, name, likeness, it was originally built around human authorship, the human way, right? But it has continued to change because of the continual iteration of artificial intelligence. So we're going to get into that. And we know that artificial intelligence, with its new iterations, not new AI, it operates on a replication that scales. And that is what most people are fearing, because the mismatch between what's supposed to be protected from me or ownership, what I possibly can lose or lose control over, there's just this mismatch. And that mismatch is the fault line. So let us go deep into this within the short period of time that we have, because we can always go much deeper. But ownership, yes, it's about what you create, what you own. It is about that. It's still about that. But now it's also about what can be copied. So we have to think about that as owners going in. And today's case study that I want to use is Scarlett Johansson. And I'm going to talk about also some key precedent cases that I learned over 10 years ago in law school. So you can see that Scarlett Johansson is a more recent case. In 2024, she publicly raised concerns over a newly released AI voice, and I believe it was through OpenAI, that sounded strikingly similar to her own voice. Even though they stated, we did not train our artificial intelligence on your voice, we did not intend to replicate your voice. She was like, yeah, no. And she raised havoc, and it pulled in public attention, public scrutiny, and then there was a pause. So we're going to dive into that and some other things as well. So again, welcome to Seek Elevation. That is what we're talking about today. If this is your first time tuning in, I am attorney Ellakisha O'Kelly. Yes, I am an attorney, but I am not your attorney. I don't know your situation. I will have to know your situation to give you legal advice. So any information I'm giving is for educational purposes, for you to take those gems, dig deeper, and figure out if it applies to your situation. If so, what are the next steps you need to do? But you have become more informed because of it, not legally advised. I'm also known as the empowerment influencer. That is my goal. That is my mission. That is my focus, is to empower. The energy in which I elevate on is empowerment. I empower myself daily. I stay elevating. I stay seeking. And this platform is also for those who want to elevate and seek to come in as an empowerment influencer. I advocate for creatives, for sports professionals, for founders, and I have a special place in my heart for first gen achievers as a first gen achiever myself. But right here on this Empowercast, instead of podcast, right here on this Empowercast, it is a space for elevation. It is a space for transformation and clarity. And my aim is to attract and identify those individuals who are rising and redefining themselves and daring to step into their highest potential. The people who want to become the best versions of themselves and own every step of their journey. That is what these segments are for. So if you are building, if you are creating, if you are leading, if you are evolving, you are in the right place. Tuning in to Seek Elevation. All right, so let's get into it. I want to talk about 4 points. I'm going to touch on like 4 different points to bring in this theme that AI is not new, right? AI is not new. Neither is theft of likeness. But what you learn can keep you ahead of or in the know of the iterations, and you can become a better owner, a better controller of your assets. And also, maybe once you have more information and you lose the dislike, maybe you can use it for your benefit to 10x whatever you're actually doing. Because remember, I told you ownership is not just about creating, it's also about duplicating. And how can you do it at scale? I know there's many times I've said, and I've hired plenty of people to do different things. One of the things that I had to do as a solopreneur is, and I'm not even gonna say had to do, because I know some people that just don't do it. But for me as an elevator, one of the things I had to do is to make sure that I studied and learned the different aspects of what I needed in order for what I'm doing to excel. So I've learned so much when it comes to, tech, media, videos, social media, learned so much hands on. I mean, on the ground, getting it. So even when I do hire people, which I've hired and bring them in, they can't BS me. I know exactly what I want. I'm able to communicate my vision clearly. I know what can be done and can't be done, at least minimum, at the basis, foundation. I know what can be done or not. If someone brings in more expertise, then the only thing different is that they should be able to go up. But I know it because I've been in the trenches. And I've always said to myself, man, why can't I just duplicate myself? Duplicate me, my mindset, and insert it in these individuals. And when I insert that drive and that mindset in these individuals coupled with their expertise, my gosh, it would be amazing. But guess what? Artificial intelligence allows us to do that. So there are pros and there's cons. But honestly, the biggest con is just not learning the information and allowing artificial intelligence to control you instead of you utilize and control it. So going back to Scarlett, in her situation, so we can just kind of build from current and then we go back, right? This is a current situation, 2024. She was approached previously to license her voice for a particular AI product. She declined it. She did not want to lend her voice, license her voice, which, okay, let's pause there. Let's put a pin in that before I go forward. My ownership mindset, my elevators that are seeking, one of the key things I said was license. She was able to license something that is an asset. We speak daily, and there's a lot of things that happen or that we are engaged in daily that I believe we take for granted. We take for granted that this human being right here shows up. There's an actual image that can be taken of this human being. We take that for granted. Things that we do, our own personal quirks, or things that we show up in rooms or around people and they become very familiar and recognize us because of those things. We may take those for granted. Our voice, just speaking and sharing that, we take that for granted. All of these things I named are assets. And for her, her voice, she was offered an opportunity to license one of her assets, which is her voice. She declined that. Shortly after she declined licensing her voice, an AI voice assistant that was launched from OpenAI had a voice that was, again, strikingly similar to hers, because many listeners that listened to this AI voice assistant thought that it was her because it was so extremely close to her vocal tone, her cadence, her delivery. They thought that was Scarlett. So, because there was this public confusion of if she was endorsing or a part of or collaborating or partnering with this AI product, she issued a public statement expressing the shock and concern of her voice being duplicated or used, and emphasizing that she did not consent for that to happen. There was a lack of consent for that to go on. And she also expressed, which was very accurate and very correct, that she's not raising a copyright issue at all. She's raising a right of publicity infringement. So when we look at our assets, when we look at what we have, our name, our image, our likeness, and things that come from that, there are so many ways to protect those assets. There's more than one way to do it. And a lot of times each of our assets has to be protected on several levels. You may hear, or you may even had said plenty of times, I need to go get this thing trademarked, or I need to go get this thing copyrighted, federally trademarked and federally copyrighted. Well, you may one thing may have to be trademarked and federally trademarked and also a federal copyright in that particular thing, not just one or the other. It may be all particular levels. And then if you come out of federal trademark, federal copyright, you also just have infringement on your right of publicity. If you are a celebrity and you have commercial use, right of publicity. If you're a lay person and you don't necessarily have celebrity status, you still have right of privacy. So there's still different levels of protection that you can exercise for your assets. And so in this case, she made it very clear we're not talking copyright. We're talking here my right of publicity. There's a commercial gain on my likeness. So, like I said, OpenAI, they stopped, they halted using the voice, and they claimed at first all the stuff I told you, we didn't do this, we didn't do that. Then they came back and said, well, we used a different voice actor. We use a voice actor to actually create this. So in that particular case, this issue didn't have to be resolved through a lawsuit, through the courts. At that stage, it escalated through the court of public opinion, if you will, the public pressure, ethical scrutiny, not judicial finding. But there are so many times that the court has had to intervene. But before I go there, I just want to talk about, again, I hope you're picking up what I'm putting down. A lot when we create content, and I'm creating content right now, and I'm using my voice, and I have federally protected my EmpowerCast, Seek Elevation, and the segments that I do. So yes, copyright plays its role in it. So if someone was to use my podcast segments without my consent, then there will be an infringement on my copyright, my federal copyright protection of my podcast and of my segment. And I'm speaking. However, there's another layer, not just the copyright part, but if someone used copyright is that actual content. But if somebody was to lift my voice from my podcast, so not necessarily replaying, using, or anything of the podcast itself, but lifting my voice from it and used it to plug in another recording, then now we're talking about right of publicity. So in her case with her voice, she did not claim that a recording was copied, that any type of written scripts that she may have said was used. That would be copyright infringement. Her concern was the sound of my voice is being used in this situation. So although federal copyright protection protects fixed authorship, fixed to a medium. When I record this and I'm done, it's fixed to a medium that you're able to replay and watch, or you're able to replay and even listen on streaming, all major streaming platforms. You'll be able to listen to it. So you can watch or listen. So it's a fixed creative work that was done in the end, and I can federally protect that copyright in that work. I already gain a copyright once it's fixed. I have a copyright, but now I can get federal protection by submitting that fixed work to the Library of Congress. But that's not what she was focused on. Her concern was my natural voice, whether you lifted it from somewhere fixed or not, was used. My vocal style was used. This particular tone or cadence was used. You ever speak to somebody and they may enter a room and start talking and you're not even looking at them and you know exactly who it is because you know their voice? You don't have to see them to know who it is. You know by the tone, the cadence, you know the voice. That means you know the asset. So that particular protection falls under the right of publicity and likeness laws, which these particular laws can be protected on a state level. They can be protected through statute, case law, but they're very inconsistent because there's no universal federal law, which would make a huge difference for us when it comes to that. The protection that one is afforded will depend on the state in which they live, the statutes that are in place, the cases that have set precedent. So it is very inconsistent. And because of that inconsistency, it's often underdeveloped for AI scenarios. Now, when we're talking about copyright, speaking of which, and I have a podcast segment I covered, it may have been last season. And I've also covered little nuggets, just giving speaking nuggets. But I believe in season 3, I covered where the Copyright Office has now issued, because they had to get on top of this AI iteration, new iteration problem, where individuals are using things like the Chat GPT or Claude or other similar ones, and they're creating images, logos, scripts, and determining if a copyright exists within those things created using those large language models. And like I talked about in that segment, it depends. It depends on prompting. There were several factors that the governing body looked at. Is there a lack of creativity in prompting? Do someone just type in, hey, I need you to create me a logo of a cat reading a newspaper, sitting in whatever room, and you're just giving it bare minimum, and then it generates all this, and it's very detailed. It's detailed on what the cat looks like. It's detailed on what the room looks like, how the cat is holding the newspaper or whatever it's holding. You just said reading something is holding it, maybe newspaper, maybe a book. It fills in the gaps you didn't. According to the governing body, that is not creative authorship. And you don't own the copyright in that generated image because it was just prompted for the GPT to be very creative in what to give you, versus prompts that were very, 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 very detailed. And the output of what was given is very reflective of the input that was given, very minimum gaps filled. So the copyright governing body was deciding still, they came out with what we're going to follow right now. And it's a continual change as things continue to keep happening. And as AI continually expands, there's always going to be new developments there. But there's a lot of things that's underdeveloped in its process of being developed because of these iterations going at a fast speed, and right of publicity is one. Copyright governing body may start to get a little bit of traction on copyright, but we still got to think about right of publicity. And we started again there, but we're going to have to dig deeper. So in this case with Scarlett, like I said, the issue wasn't theft of a copyright. It was consent and control. That's what it was. It was about giving consent and control over my voice. And so one of the legal questions that is right now constantly being resolved in the courts and governing bodies is if an AI system produces a voice. And I've seen people post about this before where somebody said, well, it was something with Jay-Z, Whitney, Mariah, and with individuals now creating these artists. I believe who was that? Dr. Dre, I believe, created an artist or something. But people question was, now creating these artists, what if you can use this person voice and that person voice? And so one of the questions being resolved now is these AI systems producing voices that is recognizably associated with a specific individual. So of course, if you have celebrity, of course, if you have somebody like a Jay-Z, you know that voice. So if it's associated with a specific individual without using their recordings, has their voice, their rights of their voice actually been exploited? Has it actually exploited their likeness? If AI is used to generate a voice that sounds like someone that is recognizable, very recognizable, is there an exploitation, an infringement of their likeness? Although this is something that's constantly being discussed, again, even more so now than ever because of the new iterations, there hasn't been anything definitive nationwide, state by state, and sometimes different states, how it works in the legal system. Sometimes different states use other states' precedent. They'll see how they held, especially if they are similar in how they look at different legal issues anyway. They may borrow from how they assess the situation, but they don't have to. So, because of the uncertainty, even though better now than it has been, there's always risks. But where we are at now, Scarlet situation, the conversations that we're having about using these voices that people claim they're not lifting from anywhere else. Why this moment is so significant now and her situation is significant is because it does expose our uncomfortable realities, right? It does expose that we understand our voice is an asset and we're depending on a legal system to continue to develop itself to protect it. With that information now, though, I'm going to give you something to empower you because we are in a moment where we're constantly, the courts, figuring out there are ways that you can have some type of control. If there's anything you're doing contractually, and that even includes, are you ready for this? Using the platforms that we're using, whatever platforms you're using, whether it's the GPTs, social media, taking the time to read the terms and conditions because most people never contractually even protect, and that is a contract. A contract doesn't mean just sitting across the table from somebody else or somebody handing you a contract to review and you both sign. Contracts are also created when there's term and conditions on platforms that you're using, and then you using it is your way of consent. So taking our time to read what our phones say, what platforms say, what GPT says, and see if you are already contractually agreeing to your voice being licensable property already. Training it for that. There's ways to set off or turn off approvals on different platforms, but it's not, a lot of times it's not even turned off because we don't read it. We just hit agree, can read things pop up and we keep going. You have to check any platform you're using, especially platforms that are created to help creatives on any level. What are those platforms' terms and conditions? So you can do your part as the legal system continues to do its part. But do also know, and this is point two, as the legal system is continue to work this through, as I just brought up with the copyright office, they've found So many things. This one young lady I talked about in last segment created a she created a not a magazine, but a comic book. She created a comic book, but a lot of those images was created by simple prompting. So she had to disclaim when she originally filed for federal protection. They gave her full protection. And then word got out, and I believe it was through her own posting, if I'm recalling correctly. It was through her own posting, but word got out that those images were created through artificial intelligence, and they dug deeper and recalled her full protection, and she had to file for federal protection of her comic book and disclaim those parts that was created by AI. So just like they did that, there's constant cases still here now where people replicate your voice and it's so identifiable. Whether they said they use something to get it or not, if it identifies you and they know it identifies you and there's a commercial gain, there's cases that keep coming where there is infringement. So we didn't copy you, like they told Scarlett Johansson. We didn't copy you is not a safe defense. It is not a safe defense. AI can imitate. The courts now know, and not now know, they see it more often now than ever before, that AI can imitate without reproducing from something that was already put down. The law's still catching up, but it's up. It's there though. So you do have recourse. Do understand that you have recourse if there is some type of AI product or creation that you are absolutely identified in that. There is recourse. So know on both ends, the person that wants recourse and also the person that if you're creating something. So no, don't say, okay, I didn't use this to create Jay-Z voice or Whitney's or Mariah's. I just programmed it or something and it just so happened to be identical. That's not flying. That's starting to get dismantled. And we do know, which is point 3, right? We do know that power, it determines outcome. And we talk about a Scarlett. She has power. She is somebody she's celebrated. She's recognizable. She's somebody that's big versus somebody who may just be a solo founder or indie creative or something like that. We know, right? Power does help. So even if you're someone that's not like Scarlett, then we need to really pay attention to positioning ourselves. How are we showing up? How are we positioning ourselves for our work to not, even if it's not celebrated at the level of a Scarlett yet, but it's recognizable. That's why a lot of us, we don't do good with using the websites, social media things. Some of us say, I don't want to do it too much, but now we have to think deeper if we're going to stay 10 steps ahead of artificial intelligence. Don't think about the showing up on a social media, the promotions and all this just about for selling a product or a service. Think about it for creating your positioning. So you become familiar. So now you are gaining your power, however small it is, it's still some power to say, yeah, no, I'm recognizable. I don't care if it's even to 1,000 people. It's recognizable versus you not positioning yourself to have some power. Because of her power, she was able to have OpenAI immediately pause because the public was behind her. That's another thing too, positioning yourself with followers in the public and they feel connected to you, your story, your thing, what you're doing. You can have advocates that's behind you when something happened. When you come to it, they're like, oh, yeah, there's advocates because you have positioned yourself using these platforms. So, although most creators, most owners, and depending on the level of athletes you are, sports professionals, or even the sports professionals that are not the athletes, but on the other side, depending on the level of power or positioning you have yourself, you may not get the same exact response as a Scarlet, but if you continue to think about that now and start working on that and stop thinking, "Oh, I'm not ready yet. Maybe I don't need to put myself out there as much. I don't have these things together." No, you're always ready to position yourself. Now with the new iterations and where we're at right now with artificial intelligence, rethink of how you are positioning anything that you're doing. You have to think bigger than sales. In marketing of a brand, you have to think position and power because I never know when I have to use it. So this is not just about using Scarlet, it's not just about a celebrity being upset and then getting her way. It's about a celebrity addressing a situation that we all need to pay attention to, regardless of what level you are on. Because we obviously know AI doesn't need permission to sound like you or to look like you. It doesn't need any of that. It just needs a human that does it, that uses it. And it also needs the absence, you, using these platforms, using whatever, it needs the absence of enforceable boundaries. Sometimes, listen, sometimes we be so excited to use certain things that we're not even paying attention to or don't even care, or we may acquiesce, meaning agree to terms and conditions that are in opposition of what we want. So go back, pay attention, read. Do you have things turned off? Do you have permissions turned off that you need to on every platform that you're using? Using GPTs, there's a button, there's a option that you can turn off or on for your specific GPT to be used to train the model. You can have that turned off. So are you paying attention to the small things if you don't want artificial intelligence using it? So, going on to point number 2. So, what does likeness actually mean? And I speak about NIL a lot and name, image, and likeness. And I've said it over and over again. For some reason, it has been very popularized through this college era of name, image, and likeness. But name, image, and likeness, as you got from point 1, it has nothing to do with collegiate sports, high school sports, or just sports in general. It has to do with you showing up as a person and the capacity in every capacity that you show up, be it sports, entertainment, or as a business owner, or just in life in general. That's what name, image, and likeness is. When we're talking about your likeness, it's a bundle of rights. Your NIL, it's a bundle of rights. We're talking about literally your name. It could be Ellakisha. It could be the ownership attorney, the empowerment influencer. So it's actually your name that's associated with you, whatever that may be, performance known as name, whatever name that you may have. Some people have these Arthur names or other type of names, just like their stage names. All of that is your name. Then you have your image, still shot. My image, you're looking at this video, you're looking at my image, you're hearing my voice, my signature. That's my signature. So why signatures are important. Important. That's why people can get in federal trouble with signing somebody else's thing. That's forgery. That's not your signature. It's not just about signing someone's name. That's not your signature for you to sign. That's not your name to sign, but that's not your signature. Your whole persona. That's what I meant by likeness. If there's a certain way, if you think about Michael Jordan, how he moved, that's Jordan. That's a persona. If someone goes to dunk a ball and have the ball up in the air and their legs split going for the basket. They equate that, oh, that's Jordan. That's a Jordan move. That's a likeness. That's not an image of Jordan. Jordan's name is not attached to that. It's likeness. You can see someone's silhouette blocking out the whole picture, but you become familiar with a likeness of someone's stature and just see the silhouette of it. There's a likeness of that person, not the actual image. There's no name attached to it, but there's a likeness. And then there's just distinctive characteristics about individuals. You have some individuals who do, speaking of sports, made celebratory dances or certain moves that they do, and they're associated with that particular person. What's his name? Jefferson, I believe his name is. Do that certain move after making a touchdown. Like there's certain things that's distinctive characteristics. And like I said, understanding how to position yourself in power, thinking about all those things will help you. Because speaking of courts and what they protect, not only has it been different state by state with right of publicity, it also has been different asset by asset. So maybe one state may look at certain protection of your name one way, of your image one way, of your likeness another way. But positioning yourself helps a lot. So if we know that if we don't have a federal standard yet, the protection depends on you. At least establishing how it can be protected, or the putting yourself in position to prevail depends on you. All right. Before I move on to point 3, I did write down to touch on this, which is this is how important it is, especially when I'm talking to creatives. We know in the world of film, there's been several strikes with actors and writers saying they're not compensated well, but more importantly, their work is not protected or respected. And there was an issue with SAG-AFTRA where AI, artificial intelligence protection, was the core of the labor negotiations. Everyone understands how important the name, image, and likeness assets are, except for the one whose name, image, and likeness is being used, it appears. We're getting better. We're getting better. So I'm hopeful. But in this particular case, yes, these actresses demanded, when you're looking at using my name, image, and likeness, there needs to be better enforcements of consent. What is the parameters of that consent? Just because I consent to one thing doesn't mean I consent to all things. But consent has been used universal. You say yes to do this, it means yes to everything. What does the compensation looks like? What are the scope and limits between the consent and compensation? What is the duration and control? These are questions that you constantly have to be asking, not just actors, actresses, whatever level you're doing, whatever level in any area you're doing what you're doing. You always have to think about these things of these assets. What am I consenting to? Make it very clear. What is the duration of my consent? What are the boundaries of it? Geographically, what is the consent? These things have to be brought up and not assumed. What is the duration and the control? Because if you don't ask it, no one's asking it for you. And one thing that these actors and actresses did see is that these unions, if the unions are negotiating things on their behalf, and whoever's negotiating anything, hopefully is negotiating it at scale. If they're negotiating it and you're not getting the expectations, the wants and the needs of who you're negotiating for, then you're not benefiting them. Individuals without, I don't care if you're represented by a union. I'm going to say this loud and clear. Individuals without counsel or someone to protect their best interests, you're already exposed. And a lot of times we'll think that a union's for us, a union's for us. A union is for a union, a body of individuals that's negotiating on behalf of a body of individuals for other people. But getting someone directly having your best interest, because as a union, my best interest may not be what everybody's interest is, right? If you're representing just a lot of people, a body of people, you're unionized. My individual interest may not. So I have to have checks and balances on this universal thought process to see if it applies to my situation. So taking it again out of unions and anything that you're doing, you're already exposed if you're doing something that is general and just accepting the generality of it. Going back to the platforms that I'm talking about, things you're using. Millions and millions of us use these platforms. The terms and conditions that are rolled out for millions of people. They're not million different types of terms and conditions. So it's not individualized. It's just, this is how it is. And the millions that use it, you're coming on here like it. So that means you have to step back and say, me as an individual, does these terms and conditions apply to my best interest of what I need? Because it's not always all wrong either. There are times that individuals may say, yes, I want this model trained on this information that I'm using. Honestly, when we're looking at artificial intelligence and we're looking at large language model to do the things that we want it to do for us, if it was not trained, it wouldn't even be able to do the things that we want it to do for us. If no one allowed it to be trained at all, artificial intelligence would not be as useful, this iteration of it, as it is. So there's a times that we do want it to scrape the internet, get these different things because we want it to show up as its best to help us do whatever it is that we want it to do at our best. So there's times that you can give permissions to this and you take away permissions from that. But again, that comes from being informed first. If everyone said no, then we wouldn't even need this iteration of it. So the point of making is understanding what your boundaries are, what they are not. Anything that's contractual, whether it's direct conversation that you're contracting, understanding the boundaries, or your use of something is participation in the contract. Go in and make sure you're understanding your boundaries, your terms, and your conditions. Because if your voice, if your name, image, and likeness is not protected, it becomes training data all the time without you choosing what you want, train or not. It just becomes it. So the real risk is not, I don't let you guys just get off the hook. I'm sorry, I'm gonna have to say that. I don't let people get off the hook. I am a strong believer in accountability. And this is why we should not fear AI. Like or dislike, your thing. Not fear, because we have to be accountable. Whatever is being introduced, we have to be accountable. We still are the human intelligence. So while most people label companies as threats, AI companies as threats, as the risk, the real risk that most people miss because of accountability is our own consent and agreement and contracts and understanding. Now, if someone violates that, then we handle it from there. But a lot of times we don't even put ourselves in a position to really be claiming someone violated something. We have technically already consented all the way through because we don't like to read and we don't like to check. We just like to go. When we're on these platforms and our consent is given by using the platforms and posting, and we don't realize that part of the terms were in perpetuity, meaning I can use what you share on here forever and ever and ever because you never clicked that button off that I couldn't. Or I could allow reposting and remixing and remaking because you never slid that button that I couldn't. There's a lot of times I allow for that because guess what? It helps me. Go ahead and repost, remix. This helps me. But this particular thing, I slide that button. No, you cannot. That doesn't help me for you to share this. You're not allowed to share this. So I put no. And just in general, since I'm on contracts, before I move on to the next section, I'm going to give you some gems, right? When you review any contracts, there are certain terms that you really do want to look at when we're talking about your name, image, and likeness, and we're talking about media. One, like I just mentioned, in perpetuity. You see that word, you know what it means. Whatever you moving forward with on this, whatever you said yes to on this, you're not just saying yes now, you're saying yes forever, beyond your life, beyond the existence that you know of it to be. Um, Also pay attention to provisions that will say you're given a right for this particular name, image, and likeness to be used this way, but you're also given it in all media now known, or later developed. So it's covering every way. A lot of that started changing, especially after the iterations of AI, especially after the iterations of how tech. In the beginning, very, 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 very earlier contracts focused on the way they understood media to just be. They didn't have the foresight of media constantly elevating and changing. And so when we constantly seen it change, and what has happened in contracts is since we don't know where we're going, when we're going there, how we're going, we're just going to put language in here that says all media now known or later developed. When you have that in your contract, it means it doesn't matter what you agreed to. You may have agreed to something being on camera, streaming, vinyl. But if for some reason it just completely changes, the media changes, you now agree to what future iterations there are in contracts that have that type of language. Contracts that mention you're giving consent now, you're giving consent for derivative works. That means I'm giving consent now for you to use whatever I'm sharing right now. But I'm also giving you consent to slice and spice this however you want, to make more works on top of this work, if that's already in the language. Because one of the things that copyrights do protect is the actual authorship of your work. And it protects not just that authorship, it protects anyone making a derivative from that authorship, meaning anyone creating something that derived from your original thing. Copyright protects that. Well, you have contracts and terms and conditions, not just in contracts you're sitting down, platforms that may have language in there saying you're consenting through your use or through your giving of derivative works to be made from what you're consenting right now. Look for digital simulations. You will have contracts now that have terms that mention about digital simulations. You're consenting to the form in which you're consenting now, but you're also consenting to digital simulations of it or some type of reproduction. So derivatives and reproduction, two different things. Derivative mean I can create something that derives from this thing. Reproduction means I can use the thing and reproduce it. So founders, creatives, sports professionals, those are things that I'm just going to give you some type of language. Those are just a few. There's so much more that you can just skim through terms and conditions and contracts to see if you see any of that. So you may have to replay this and just get that. But those are just some of many of language that gives rights now and beyond. Or there's language in there that you think you are giving a right, assigning a right, but you're actually giving up. So be very careful and understand the terms and conditions. You're not losing your rights to artificial intelligence. You're losing your rights by you not doing the due diligence to see what's what. All right, point 3. This is what I really wanted to get to, what I talked about earlier, where I said that as humans, we have very short memory span. Everything is new to us all the time. We'll go through something, it happened, then it goes away, and we fast forward and we're like, this is new. Oh my gosh, this is worst time ever. We're in our worst era. This is the worst life. We'll say that. And it was already the same before that. Before that. Uh Scarlett Johansson, obviously happening in 2024 and many others, it's not the starting point. It's not the starting point. Her issue of replicating her voice, it's not a new legal problem. Us talking about, oh my gosh, with AI now mimicking voices, is it okay? Is that going to be? That's not a new legal question. These questions and issues are just modern examples, modern right now, of what courts have identified decades ago. And like I said, because it wasn't this iteration at this level, at this speed, it was not as often. So courts have to catch up on the new iterations, but not AI. Can someone commercially exploit your identity by imitating you without using your actual image, name, or recording? Was the question that I asked earlier. And it was a question that has been asked for years. It's just made it unavoidable at scale. There are 3 key cases that I talked about during my time in law school when we talked about AI. And mind you, so that was over 10 years ago. And we weren't where we are at now, we weren't there then. And even then, we're talking about cases that was way before then. So Bette Midler, there was a case that we talked about with Bette Midler, and it was about using her voice, her asset as property, and not as performance. In this case that we learned in college was Bette Midler against Ford Motor Company. Ford Motor Company had used Bette Midler's what they called a sound alike for a commercial that they had put out. They had asked her, just like with Scarlett, they had originally asked Bette Midler if she would lend her voice for this commercial. She too, like Bette Midler, refused to do so. So they made the sound alike. At first, the court said, well, the lower courts, the district court said, Ford, you're fine. There's no legal principle that prevents imitation of one's voice. There's no legal principle. You didn't use her voice, you just imitated it. And Bette Midler said, no, I'm going to appeal this. They went to the higher court. That's what you talk about appeal. And the higher court reversed that, saying that, no, you wanted Bette Midler for a reason. You wanted her voice. You knew it was familiar, obviously distinctive or recognizable to the public. That's why you chose her to do your commercial. And so, with right of publicity, and you using her voice that is familiar to individuals, which could also cause confusion to the public thinking, oh, Bette Midler is endorsing this product. You are protected from this appropriation. You can't just appropriate someone's voice for your commercial gain. And so, yes, although there is the First Amendment protection of speech and all these things, there are also exceptions to those things. That's a whole nother podcast too. I covered that in my very first season about First Amendment. We always throw away the First Amendment. First Amendment protects certain speeches. Certain speeches are outside of it. But we won't. I digress. But the court found no. The higher court, no, absolutely not. There is appropriation. So there is a legal law for that. So you all see right now, even in the courts, the lower, higher, how they seen it totally different judges sitting. But again, it set precedent. And it wasn't new. Scarlet, modern, but not new. And so courts can even revisit some of these cases, and very competent attorneys would research cases that supports their legal argument. That's what we will have to do as competent attorneys. Not only would you research cases that support your legal argument, you will research cases that do not. So you know how to address all sides. But Bette Midler was asked to sing. She declined. Then they said, well, we're going to go ahead and create a sound alike, the same way we're talking about right now. Can we create sound alikes? Jay-Z, Whitney, Mariah, we're going to create a sound alike. And we're going to use that voice intentionally designed to imitate her because she didn't actually want to do it. But we didn't bother you. We just created a sound alike and we ran a commercial anyway. It's the same questions we're asking now. And although the lower court said it's fine, the higher court said it's not. So again, no need to fear AI. Just be educated. Be knowledgeable. Know what exists, what has happened. This matters because, again, distinction matters. Having something that's recognizable matters. Remember, we talked about positioning. So as owners, ownership mindset at least, you don't need to copy someone's work. You make sure you don't do that. And someone doesn't need to copy your work in order for them to actually be stealing your value, is what you need to walk away with. So you need to understand, you don't be out here saying, okay, this is AI, I could do what I want to do. You can be stealing someone's value, and don't allow someone to do it to you because they could be stealing your value. Position yourself. Evoking someone's identity for commercial gain is enough to fight. Another case that we talked about in law school was Tom Waits. He had a case against Frito-Lay's. And in this case, again, they use voice, misappropriation, and what they also raised as what's called false endorsement, which, again, if the public think that you are endorsing something, is false endorsement. And in this case, the court had held that the voice misappropriation using Tom Waits' voice was not stopped by copyright law, and that false endorsement could arise. We know this from imitation of confusing consumers. So I keep repeating that. So when you ask yourself this question, if I'm not taking directly from a person, but I am just creating something from scratch, from maybe you know how to do all the language modeling and all that stuff from AI, and you can make it spot on. If you create confusion to customers and you know why you're choosing someone's voice, then it may be false endorsement, a violation of a right of publicity or privacy for somebody who's not celebrated. and you may have to pay up a lot. So do know, again, these conversations were already happening. When it comes to voice, when it comes to likeness of an individual, they also use a sound alike. And they created an impression to the world that Tom Waits was obviously endorsing that product. So when we're thinking about artificial intelligence, we have to realize that we're not just talking about replicating uh, just identity. It's a situation where it creates implied endorsement through AI. So no reason to fear, just to know and to understand how to address it. How to address it if you're on the end of being replicated, but also how to be informed if you're on the end that's creating. Another case that was huge, and this one wasn't about voice that we learned. Another key case that we learned in college, speaking of replicating name, image, and likeness, was Vanna White. How many people have watched The Wheel of Fortune? Wheel of Fortune was a thing. And Vanna White was the face of Wheel of Fortune. Like, if you know Vanna White, the host, Wheel of Fortune. And this case, we had Samsung that used Vanna White's image for its robot or whatever it was creating. And everything about this robot, it was dressed to resemble Vanna White. Positioned, it was positioned on a wheel, a fortune style set. Everything that when you seen this robot, you thought of the likeness of Vanna White. You didn't have to see an actual image. You didn't have to hear an actual voice, but you knew everything was the likeness. They brought consumers and anybody else who watched to the mindset of Vanna White. So they use no name. They use no image. But their argument was, well, we didn't use her. We didn't use her. We created through this robot, this artificial intelligence, our version of this that may resemble this, but we didn't use her in any way. And the courts disagreed. The courts disagreed with that argument. It didn't matter you didn't use her. It didn't matter you use her name. It didn't matter you use her voice. The court said the right of publicity protects identity, not just literal images, not just the sound of a voice. It protects identity. How can one identify you through this? Is that possible? That's what the right of publicity protects. So when you invoke someone's, again, persona for commercial gain, you're selling something, you're getting paid for it. She's not getting paid for it. You used the persona she built to build a loyal following of fans, getting to associate her with this persona. You use that, you lift it from that to create your robot. And so the courts was like, yeah, if we allow this, then that would just let advertisers exploit anyone who's known, very familiar face to the world and the public, or familiar characteristics or persona to the world, without paying anybody anything. You wouldn't actually need them. And that's where we are right now, right? With artificial intelligence. People keep having this conversation that will you actually need a human to sell this or to do this? We probably won't need a human to promote this product or this service. We just artificially create what we need that may resemble someone familiar. That's a negative. It's a no. Do not fear. Just become more knowledgeable. You still have protections. And I'm going to say this again. If you're not someone who is a huge celebrity, you still can position yourself using your platforms constantly, even your website, not just these social media platforms, but your actual website, whatever it is, position yourself to become known for this thing, this image, this likeness, this name. That positions you. So when we're looking at these AI avatars and digital doubles, voice models, people say it's not actually them. That's not a self-defense that can be relied on. Precedence has shown us. The law has already spoken, but it's going to continue to take individuals to continue to speak the law. New iterations of AI made things profitable. Technology made things profitable, but there has been and still is recourse. So, what does proactive ownership look like in this AI era? Point 4. What does it look like? And I'm sure now you should be able to say it along with me. Out of the first 3 points that I already made, you should be already able to say it, uh, what this era looks like. We already talked about, you know, point 1, just understanding in general, using Scarlett Johansson as the modern case, that it's not just about copyright. So if somebody want to shoot down something because they say it's copyright or this, no, core legal issue that we're talking about, especially when we're talking about replicating, duplicating, and name, image, and likeness, it is the right of publicity or right of privacy, depending on what you are. And then point 2, we also talked about just in general, what name, image, and likeness, what does that actually all, what does it even mean? And they're all different levels to it. There's a bundle of rights that you actually have when we're talking about name, image, and likeness. And you have to make sure whatever platforms and things that you're using, you are being intentional about protecting those different levels of bundles of rights. Otherwise, you may be giving consent, unfettered consent, without boundaries if you don't understand it. And I gave you some key terms and provisions to look for in contracts or agreements. And then the third point I talked about was that Scarlett Johansson and any other celebrated person that we're talking about right now, modern times, or 2024, 25, you're gonna hear 26 and whatever, it's not new. AI is not, artificial intelligence is not new. The level and iterations of it is, but we can't have a short memory span. Some people just probably didn't know at all. Now you know. But we also just have to pay attention to anything that's going on. Is this really new? Or is it just at scale? So we talked about that. It's not new. And I went over some key cases that we discussed in law school that set that precedent when we talk about voice or likeness. There were plenty of other cases as well. But for the sake of not bringing you to law school, I just picked out those cases, but there's plenty of cases. So you have recourse if you on one end of the stick, and you have to think about what you're going to do before you do it and stop reading what everybody's saying you can do. You have to think about what you're doing to see if what you're doing is even going to be protected. That's the ownership mindset on both sides. Not fearing that you have no recourse. Let that go. Don't fear that. You do. And then on the other end, know that you can't just do any and everything you want because artificial intelligence have scaled up. As an ownership mindset, you have to make sure, is this even protected what I'm doing? Can I get in trouble for infringement? But also, am I creating something that can't be protected? I've seen someone, I've been to AI seminars and I'm watching them teach people how to make logos. And the only thing I'm thinking in my mind is, you can't trademark that. Oh, this thing right here can't be federally, you can't federally trademark that. That can be federally copyrighted. That's, you really don't, that's not yours. Those prompts aren't enough. They can be challenged if somebody ever challenges you. So, and then we're wrapping up with the point 4 of, just what does proactive ownership look like? And I want to say it again. This is not about fear. We cannot fear. We're the human. We control, but you will fear if you don't learn. It's not about fear. It's about foresight. But you want to seek elevation and you're learning. So foundational moves for you as owners in whatever lane that you're in, any way that you're licensing your assets. And I'm going to say this again. When I say licensing, it doesn't mean you're having, it's not always you having a direct conversation with another human across the table. Anything that you participate on, platform, phone, and you're utilizing your name, image, and likeness in any capacity, narrow the specific purposes of which you are licensing, because that's what you're doing. Every time when we're just even engaging, we're licensing. Narrow that. If you ever come across a platform where you find you can't narrow it, you have to decide if that platform is for you to use, if it goes against everything you want it to be for. Understand not just your specific purposes, but what is the time, duration of the use. Separate your asset entities. Your name is one asset. Your image is one asset. Your likeness is one asset. All that persona is different asset. Separate how each one can be used and how you want it to be used. And understand brand ownership independent of platforms. So are you leveling up the protection of your brands? Are you getting the federal protection where there is federal protection available for you? Are you doing all the steps to get that federal protection? Because it even helps you on the things that are not federally protected. Because all of it is part of the argument that you can bring to the table. When we talked about positioning, not just positioning yourself to get familiar and people get familiar with you, but positioning yourself that you're thinking with the gold standard ownership mindset. Everything that you're producing that can possibly be federally protected, it could take you from this level of protection, which may be common law or whatever state. If there's a federal level, I'm going to go up to that federal level. So then if anything is infringed upon you, you have all the things in the bucket to bring to the table to raise an argument. So understanding complete brand ownership. You are a brand. When we're understanding protection, it is not equated to resistance. I love these new iterations. I don't love how we have lack of control in them. But I love the iterations that help make what I'm doing that much easier, where I can duplicate. I can hire more of Ellakishas to do what I need to do. I can hire other people around. And not only that, one of the things for me that was super draining was when I was hiring people and having to constantly train. I can create things that can continue to train for me. So I love it. What I don't love is when we don't understand and we don't maintain the control. That's what I don't love. So protection is not resistance to progress. It's participation with leverage, with knowledge. Then you choose a dislike or like if you want. But it's not fear. It's not resistance. It's understanding. So in closing, AI, artificial intelligence, which is not new. The attempt of theft or replication or whatever of likeness is not new. This all of this just didn't happen. AI, artificial intelligence in and of itself is not stealing identities. It is exposing those of us who never secure our identities or position ourselves to enforce our rights on those identities. We're not moving forward for our future with the question being asked, who's worked the hardest? Where we're moving right now with the new constant iterations, the new iterations, not new AI, new iterations. Where we're being asked is who owned the rights to themselves, who understood and controlled and managed the rights to themselves before these new iterations made replication effortlessly. Who understands their rights even when replication becomes effortlessly? Who understand precedent, meaning what has preceded them in conversations that have happened, situations similar has happened. How has that came down? And what arguments do they have to stand on? Ownership has always been about the assets, and I'm constantly going to speak on these assets. But we have to add another checkbox. Ownership is also about the knowledge and understanding that one has during this existence in a digital economy. So, although we're still working some things out, some things are still being worked out. Do know it has always been said and found in the courts that your voice is property. Your image is property. Your likeness is property. And you have a right as a celebrity or a layperson through right of publicity or right of privacy. Those rights, there's different factors in how those rights actually are incited and protect you, but understanding that you have rights. And that your persona, that everything about you has value, and stop moving like you don't. Everything about you has value. Stop just focusing on this product and service you have. Everything about you has value. So don't let anybody commercially hijack without consequences. And don't you, if you on the other end, get caught up in all this hoopla people talking about thinking that it's okay to commercially hijack, thinking that you don't have consequences. Let us all operate with an ownership mindset on whatever end of the spectrum we find ourselves on. And it's a sliding scale. We will find ourselves on both ends at one point or another. But we're going to always operate, no matter which way we slide, with the ownership mindset and not fear artificial intelligence that has been here forever. I'm from dial up computers. We may have fast internet now, but from dial up, from beepers that went to cell phones to it's been here. We've had robots. Let us just stay in control. And the only place that you can start first is in your space. Stay in control in your space. Do not fear. Whether you choose to like or dislike is on you, but do not fear. Become more knowledgeable and make it do what it do. Thank you for tuning into this powerful conversation. Artificial intelligence, new iteration. Artificial intelligence, not new. Remember, the more you know, the more you grow. The more you learn, the more you definitely can earn. But when you share, you show care. So please share this segment with as many people as you can. Let's get on board with artificial intelligence, the same board. Again, whether we like or dislike, let's get on the same level of understanding at least. So share with as many people as you can. Don't keep this knowledge to yourself. Tag friends, share the link, do all the things. But until next time, I want you to keep striving. I want you to keep growing. But most importantly, keep seeking elevation, peace, and progress.